Once again, as she indicated, I'm with the Polk County Attorney's Office. I've been doing this job for about 25 years. Last year we did almost 800 mental health commitments in Polk County, and we're on track to do 800 this year. So it's gone from when I initially took this job at about 360 to almost 800. It's been quite a jump. I realize what's going on currently in the status of the law in general in the United States and some of the problems we have, things like Virginia Tech, those sorts of problems. I frankly, while I have some opinions with respect to that, I'm not here to advise you as to those items today. What I will advise you as to is the state of the law in the state of Iowa. And you'll look on the slide in front of you, it has a caveat. The procedures I'm going to discuss today are the current state of the law in Iowa and its application in Polk County. We do some things a little bit differently, and I'll get to that when we get to there. In some areas in Iowa, the construction may vary. I'm sitting here trying to, there we go, okay. Okay, it's not advancing. There we go, all right. There are 4 statutes and 1 Supreme Court rule with respect to the law in the state of Iowa. And realize one thing, they're all different standards. So we don't have just one standard. When you're talking about each one of these statutes, it is a different standard. And you need to keep that in mind. If you take nothing else away from this, I want you to take away the idea that there are different standards with respect to each one of these. The first one is Chapter 229, which has to do with an individual who's seriously mentally impaired or suffers from a serious mental impairment. The second is 125, which has to do with the substance-related disorders as was amended in 2012. It used to be chronic substance abuser. It's now called substance-related disorders. I'll get to that in a minute too. 812, which has to do with incompetency to stand trial, and you'll notice the quotes around incompetency to stand trial. I hate that word, and the reason why I hate that word is because what we're looking for is a definition that's contained within the statute. And just like in 229, we have dangerousness as a shorthand. People have different concepts of dangerousness. People also have different concepts of what incompetency is. And so you need to carefully look and look to the statute to decide what that really means. Then there is 222, which has to do with intellectual disability. That was recently amended too. It went from mental retardation, now it's called intellectual disability. And then the last one is the Iowa Rules of Criminal Procedure 2.228, which that's slightly changed. It used to be not guilty by reason of insanity or diminished responsibility, and now it's an acquittal on grounds of insanity or diminished responsibility. The elements of 229 are as follows. A person with a mental illness, and because of that mental illness, lacks sufficient judgment to make responsible decisions with respect to their hospitalization or treatment, and either A, is likely to physically injure themselves or others if allowed to remain at liberty without treatment, or B, is likely to inflict serious emotional injury on family members or others, or C, is unable to satisfy their needs for nourishment, clothing, essential medical care, or shelter. That's not advancing. Okay. Got it. Okay, the elements of 125. 125 is a substance-related disorder, which means a diagnosable substance disorder of sufficient duration to meet the diagnostic criteria specified within the DSM-5, actually the most current DSM, in this case DSM-5, that results in functional impairment. In Polk County, we also add some additional stuff. And the reason why we add that, frankly, is, and I'll get to this later on in my talk, but the reason why we add this has to do with O'Connor versus Donaldson. What O'Connor says is, absent dangerousness, you can't hospitalize somebody against their will. And if you'll look to that definition, you won't see any place in there that indicates what the dangerousness is. So in Polk County, we add that. We add that they lack sufficient judgment to make responsible decisions with respect to their hospitalization or treatment, and that they are likely to physically injure themselves or others, or likely to endanger their health if allowed to remain at liberty without treatment. 812, if at any stage of the criminal proceeding it reasonably appears that the defendant is suffering from a mental disorder that prevents the defendant from appreciating the charges, understanding the proceedings, or assisting effectively in the defense. That is not, that none of those say incompetency. What they say is they have to be unable to appreciate the charges or understand the proceedings or assist effectively in the defense. So any three of those, any one of those would get you into the realm of 812. With respect to Chapter 222, it's a person who, as a result of inadequately developed intelligence, is significantly impaired in their ability to learn or to adapt to the demands of society. Once again, we look at the dangerousness, whether or not there is dangerousness is required by O'Connor versus Donaldson. And so in Polk County, we add that they lack sufficient judgment to make responsible decisions with respect to their hospitalization or treatment, and that they are likely to physically injure themselves or others, or likely to inflict serious emotional injury, or incapable of satisfying their needs for nourishment, clothing, essential medical care, shelter. Are there any questions on these? Okay. I don't know if any of you have ever done one of these, but you're sitting here and it's kind of a cold room. Now Cindy's in here, and I can't remember the other young lady's name, but I have two people in here, so I have somewhat of an audience. But if you've ever argued before the Supreme Court or the Court of Appeals, you understand that it's terrible to have a cold bench. And so if you have questions, feel free to ask. I'm not going to be embarrassed or upset by any of those questions, because frankly, I need those to get my topic to move along. Okay. Doesn't like me again. All right. The last one is Rule 2.22, subparagraph 8. A person is acquitted of a crime because of insanity or diminished responsibility. So let's talk about who can be committed under Chapter 229. First of all, it requires a person with a mental illness, and because of that mental illness, in other words, you have to have a causal connection between the mental illness and these other types of activities. So because of that mental illness, they lack sufficient judgment to make responsible decisions with respect to their hospitalization or treatment. And because of that mental illness, meets any of the following. So once again, causal connection. Is likely to physically injure self or others if allowed to remain at liberty without treatment, or is likely to, and I've redone this PowerPoint so many times, sometimes I take out the ors, but the last three are ors. Or is likely to inflict serious emotional injury on family members or others unable to avoid contact with them, or is incapable of satisfying their needs in the area of nourishment, clothing, essential medical care, or shelter, such that it is likely that the person will suffer physical injury, debilitation, or death within the reasonably foreseeable future. Okay? So what constitutes a mental illness? When we're looking at that, we look at the definition that's in 229.1, subparagraph 10, and it says every type of mental disease or mental disorder, except it does not refer to intellectual disability as defined in section 222.2, which is intellectual disability, or to insanity, diminished responsibility, as we would have within the criminal case, or mental incompetency, 812 again, as those terms are defined or used in the Iowa Criminal Code or in the Rules of Criminal Procedure, and I think it's still the third edition is this most current one. So what it really means is practically the DSM-5. Now, what is the DSM-5? The DSM-5, if you look at the introduction to the DSM-5, it'll say it's a categorization of all mental illnesses. So that's why we looked at that. I had a case a number of years ago. It's interesting, whenever you're dealing with juveniles, the doctors do not want to say that the person's mentally ill. Why is that? They're too young to be mentally ill. Well, okay. But anyway, I had Dr. Nightingale, and I use his name because I know he'll want to shoot me again. But anyway, Dr. Nightingale, I had him, and I said, and I had a juvenile, and I said, Dr. Nightingale, is this person mentally ill? I asked him before we had the hearing. He says, no, they're not mentally ill. I said, why is that? And he says, because it's a juvenile. Okay, all right, fine. I said, do you have a working diagnosis? And he gave it to me, and so we get into the hearing, and I asked Dr. Nightingale, I said, do you have a diagnosis for this individual? Realizing, of course, if you don't understand this, you should, and that is, to have a person in the hospital, you have to have a working diagnosis. So he's got this working diagnosis, and it's contained within the DSM, at that time, the DSM-4. And so I said, is that contained within the DSM-4? And he said, well, yes, it is. And I said, doctor, can you explain to the court what the DSM-4 is? And suddenly he got this puckered up look on his face and was not happy with me. But we got the mental illness in there, not because he was going to say it was mental illness, but because it's contained within the DSM-4. And now it's the DSM-5. All right. So what do we have to show with respect to a proof of lack of judgmental capacity? The code requires proof that a person lacks sufficient judgment to make responsible decisions with respect to the person's hospitalization or treatment. I cannot tell you how many times I've run into doctors who say, well, if they're not psychotic, they have judgmental capacity. Well, wait a minute. Do they have sufficient judgment? No, they don't have sufficient judgment, but they have judgmental capacity. Yeah, they have judgmental capacity. So anyway, you want to make sure, once again, you ask the correct questions. And so you want to know, do they have sufficient judgment to make responsible decisions? In Osing and Moore, those particular cases, the respondents, people being hospitalized, believed that they were not mentally ill in direct deference to the doctors who were treating them. And the court said that shows a lack of judgmental capacity. So generally speaking, the question we ask is, have you asked them to get some help to the applicants? Have you asked them to get some help? Yes, we have. And what do they say? They don't need any help. There's nothing wrong with them, okay? Or we have the doctor on the stand and we ask the doctor, have you talked to them about accepting the treatment? Yes, and what do they say? They don't want it. Those two things would show a lack of judgmental capacity. There are a number of other things too. I'm not going to tell you that that's everything that there is, but those seem to work pretty good for me. So generally, respondents lack judgmental capacity when they don't believe themselves to be mentally ill, or they don't need treatment in direct contravention to the doctor's testimony. Okay? All right, dangerousness. This is the most significant of the elements. This is the element that really your case lives or dies on. It was created by the United States Supreme Court in O'Connor versus Donaldson. Prior to O'Connor, they had a loco parenti type of attitude. What that meant was, we're going to act as the person's parents. So we just weren't looking for any specific acts of dangerousness. What we're looking for is their failure to cooperate. So if they had lack of judgmental capacity, generally speaking, you were doing commitments. Well, O'Connor versus Donaldson came out in 1975, and what the Supreme Court, the United States Supreme Court, said in that opinion was, absent dangerousness, we will not hospitalize somebody. You cannot hospitalize somebody against their will. So it requires a dangerousness element. Well, the Supreme Court laid out dangerousness as likely to physically injure self or others if allowed to remain at liberty without treatment. That was the one that they set forth. And in the footnote down below that particular pronouncement, they indicated that there may be other elements of dangerousness as well, but we're not going to address those. We're just going to address this one element of dangerousness, and certainly legislatures are certainly welcome to create other elements of dangerousness that they so desire. But we're looking for that particular element that would demonstrate that a person is either dangerous to themselves, dangerous to others, those sorts of things. And dangerousness, once again, I hate that word because everybody has a different concept. But at least in Iowa, they're likely to physically injure self or others if allowed to remain at liberty without treatment. That's the one set forth by the U.S. Supreme Court in O'Connor versus Donaldson. And we have two others in Iowa, and I'll talk to those in a minute. There are three ways to prove dangerousness in Iowa. Now, Iowa follows, obviously, all the 50 states with respect to likelihood of physical injury to self or others, because that's the mainstay. That's the one that everybody uses because that's the pronouncement made by the Supreme Court. But we've added two others. Is likely to inflict serious emotional injury on family members or others who would avoid contact with them if allowed to remain at liberty without treatment. There are a smattering of states that also agree with this particular one. And the last one is incapable of satisfying needs for nourishment, clothing, essential medical care, or shelter, such that it is likely to result in physical injury, debilitation, or death. I like to call those bridge cases. We have, at one time, only Iowa and Hawaii, and I haven't had a chance to look at it recently, but at one time only Iowa and Hawaii had this particular element as an element of dangerousness. Part of the reason we have that element is we have winters. I mean, how many people here have not been through a winter in Iowa? And if you haven't, get ready, it's coming. But we have winters in Iowa. We have a lot of people who will go outdoors and believe that they don't need any protection when they're outdoors. As a matter of fact, we had a guy one time who indicated, well, I don't need any protection because my parents grew up on the North Slope of Alaska. Now, part of the problem was it wasn't true that they grew up on the North Slope of Alaska, but the other part of the problem was it doesn't make any difference. People who live in Alaska dress appropriately. So you can't be running around in T-shirts and shorts in January when it's 20 below zero. And so we had some cases where the people had actually died. We found them in dumpsters. And the National Alliance for the Mentally Ill of Iowa, and if you're not familiar with them, if you're going to do this kind of practice, you should be. They are probably at the forefront of education and those sorts of things. And I can't tell you enough good stuff about the National Alliance for the Mentally Ill of Iowa. Margaret Stout was the director when I first came on board, and she's a wonderful person, a wonderful resource. I know that she's no longer the director, but certainly their new director, you have access to her as well. But anyway, they got frustrated with the fact that likely to physically injure self or others wasn't enough in some of these cases, and so they added this as incapable of satisfying their needs, and they legislated it, they lobbied for it, and so as a result of that, Iowa has that as one of the elements of dangerousness. Okay, and one of the things I want to talk to you really briefly about, because I'm not going to go through all 125, but one of the things I want to talk to you about, once again, remember, 125 and 229 are different beasts. They have different elements of proof. In 125, you have to show that the individual is suffering from a substance-related disorder of sufficient duration to meet the diagnostic criteria specified within the DSM-5 that results in functional impairment. Well, the Iowa Supreme Court, in the matter of EJH, took this up, and it was in a 125 case, and obviously 125 and 229 are somewhat different beasts, but they also said that the United States Supreme Court has noted a finding of mental illness alone cannot justify the states locking a person up against their will, okay? And we all agree with that. And then they went on to say, we believe that the same principles that govern involuntary commitment also involve chronic substance abuse. Now, we've changed that, obviously. Now it's a substance-related disorder. But what the Supreme Court says is you can look at 229 in interpretation of dangerousness with respect to 125. Okay. Filing of an involuntary commitment. That's done under Chapter 229, 229.6. It's an application, so I like to describe it as a warm body, accompanied by a doctor's letter, one or more supporting affidavits, or corroborative information. Now, corroborative information, when I first took this job over 25 years ago, was somewhat confusing. What is corroborative information? Well, I pondered and pondered, and I finally realized, pretty simple. A person with a suicide note signed and dated, okay? John says he's going to kill himself. He said so in a suicide note, and he signed and dated it. Now, how often is that going to happen? Probably not often, and very often at all. But at least corroborative information, things of that nature would be helpful for you. The clerk is there to assist you. Assist the applicants, I should say. And the application is reviewed by a judge to determine if the respondent is to be held pending the hearing. 229.11. It's not a question of whether or not it's adequacy on its form, but it's a question of whether or not they're going to be picked up and held in the hospital. Now, there's another alternative. 229.11 gives you three alternatives. And once again, I'm running over my PowerPoint. So I'll leave that until we get to that in just a few minutes. The notice, copies of the application, supporting documentation, together with notice are served upon the respondent. So when the deputy goes out, it's a sheriff's deputy who goes out and does the service. The sheriff's deputy goes out and does the service. They hand the individual the notice. If they're picked up under 229.11, if there's an immediate hold under 229.11, they're going to take them into custody at the same time as service is achieved. Okay, representation of the respondent, and that's, I know for some of you that's really important, and I would agree with that, and I'll also get to that in just a minute. But after filing the application, the court determines whether or not the respondent is represented, okay? And for all of those who aren't here, you could raise your hands as to how many times that's ever done, because generally speaking, the court doesn't worry about that. They're going to appoint counsel at the same time that they take the application. The reason is because we have to do an investigation. It's so much, we have 5-day turnaround, so we don't have a whole lot of time in which for respondents counsel or even for applicants counsel to get kind of this whole thing put together. And so what we want to do is we want to get them the service of an attorney as quickly as possible. And so what generally happens is they appoint right at the time that the application is taken. All right, 229.11, order for immediate custody. I have a couple caveats, and I have a big white thing at the bottom that says this is not a commitment. The bottom line on this is the process that we're going through when we pick them up does not mean they're committed. So if they do not want to cooperate with treatment, they don't have to. So that's a caveat. Respondent may not be treated involuntarily during the 229.11 pickup unless it's necessary to preserve the patient's life or control dangerous behavior. We've had cases where the individual is trying to climb up through the ceiling to get to nursing staff on the other side of a wall. That was pretty dangerous. So the doctors do notation in the chart saying we're going to medicate this guy because he's doing these kinds of things. But anyway, it takes that. So if you have a calm person who walks in and they say, I don't want to take my medication, well, it doesn't happen until after the commitment occurs. This is not a commitment, okay? All right. It's pursuant to 229.11 in the Iowa Code, and it's after a review by a judge or referee. Now, we don't have, I'm aware of only one referee that we still have in the state of Iowa, and he may be gone now, but that was the only referee I was aware of that still was in place. Generally speaking, now we have judges or magistrates. Holds the respondent until the time of hearing for purposes of examination. It's to evaluate the individual to determine whether or not the elements are going to be met. Remember, once again, mental illness, lack of judgmental capacity, and dangerousness. Okay. 229.11, and I don't have that on my slide, but 229.11 has three alternatives. The first alternative is in the custody of a friend or relative. Okay. The second is for lack of a better term, a substance or mental health facility, treatment facility that's kind of a halfway house or an outpatient type of setting. So they're not, once again, they're not restricted to a hospital. And the last one is hospitalized. Okay. So realize out of the three, only one of them requires them to be hospitalized. Now, the last thing I will tell you is under 229.11, you cannot put a person in jail. Forbidden. The statute says you cannot put a person in jail for purposes of holding them for a commitment. Any questions on that? None? Still? I'm sitting here looking at Cindy. She's going, no, we're okay. All right. Emergency hospitalizations. This has undergone some recent innovations and changes. As a matter of fact, just last year in July of 2015, it used to be when the courthouse was closed. Well, that's been removed. So immediate detention is permitted when it appears a person should be immediately detained and due to serious mental impairment, but the application's not been filed. I have yet to figure out what that exactly means, but I suspect what it means is that if they haven't had a chance to file it, they can go ahead and have it picked up. Now, generally speaking, the way the pickup works is you have a deputy who goes out and observes the person doing things that would indicate that they're likely to physically injure themselves or others. They can take them into custody and take them over to the hospital for evaluation. Or you have other people, it doesn't have to just be a deputy, that they can pick them up and take them over to the hospital. I like to call one of these kind of the roll Aunt Martha up in the rug routine, because you cannot breach the peace. Realize you cannot breach the peace. So if you set Aunt Martha down carefully onto the rug, roll her up, and put her in the back of the station wagon and take her over to the hospital, you're not breaching the peace. But if the breach of peace occurs, you've got to back off, because that then becomes a criminal activity by you as the applicant or as the person filing. All right, this is sometimes referred to as a 48-hour hold. It holds the person for one day and then the end of the next secular day. So when the courthouse closes on day 2, you're done. So it's not a true 48-hour hold, but it's 48 hours because that's what the code says, but the bottom line is if the courthouse isn't open, you can't file at that point, so there's no other way to hold them without a filing. All right. Understand one thing. I want to back up just a minute. When we're dealing with emergency hospitalizations, we are not dealing with commitments, all right? Not a true form of commitment. The commitment is where you file, the person's picked up, they're evaluated, you have a hearing. An emergency hold is just that. It's to try and get past the emergency. So if this person is having a breakdown, we can kind of get them treatment and get them into the hospital earlier than would have occurred if we'd gone through the regular process. So what you have to do is realize this is not a commitment. So if you're holding them for 48 hours, you're not committing them for 48 hours. They're on a hold. And it's really difficult to separate commitment from holds. So I want to make sure that everybody understands that at this point, because there's a lot of confusing type of stuff about whether a doctor can release or whether a doctor has to hold and that sort of stuff. Under a 48-hour hold, under any of these holds, it's exactly that, a hold. That means that the physician wants to release them early, they're welcome to do so. All right? There are some things with the Ed Thomas bill that you also need to be aware of. You can have a hold. The Ed Thomas bill permits the sheriff's deputies or law enforcement to file a request to hold this person after they're about to be released so that they can be jailed. So that you can do that as well. And that can even be done under a hold, but realize it's a hold, okay? All right. There are also a number of other holds, actually, too. The first one is the next secular day hold, sometimes called a 24-hour hold. It's when the courthouse is closed. The doctor is voluntarily already in the hospital. So that's the key. 48-hour hold, they're not in the hospital. 24-hour hold, they are in the hospital already and they want to leave. The doctor does a notation in the chart and they can hold them until the close of the clerk's office the next day. Like again, not a true 24-hour hold, but essentially next secular day hold is what it amounts to. Interesting. So think about this. The person comes in on Friday and they want to leave. Notation in the chart. They can't leave until Monday. Okay? Don't count Saturdays, Sundays, or holidays. The second one is a 5-day physician's hold. This is one that people look at me with these question looks and like I've got a screw loose or whatever, or horns on my head. I don't know. But anyway, the 5-day physician's hold is an order from a judge based upon a physician's letter. This first cropped up with us in the 90s, the late 90s. We had a new medication or a new drug out there. It was called methamphetamine. The register took them 10 years to figure out what was going on, but we knew immediately because we had lots of people coming in under the influence of methamphetamine. Well, for those of you who are familiar with it, methamphetamine, for all intents and purposes, looks like a person who is paranoid schizophrenic. So is it paranoid schizophrenia or is it methamphetamine? And frankly, the court wanted to know. And so what the physicians would do is they would do a letter saying, we believe this person to be seriously mentally impaired, in need of immediate treatment. They could even throw in, we don't know whether it's methamphetamine or if it's whatever, but we're asking for an additional 5 days. Now, 5 days is not mandated. You don't have to have 5 days. The court can order 3, the court can order 2. In methamphetamine's case, we had 72 hours. The drug is metabolized within 72 hours. So we don't have a person under the influence at the end of the 72-hour period. So what the judge would generally do is say, you have 3 days. At that point, when they came down, you'd know what it was. So that was a benefit. The court is certainly welcome, and I've lectured to magistrates before. They're certainly welcome to enter an order for a 5-day physician's hold. Once again, it's a hold. It's not a commitment. Okay, this person is not won't have a commitment. Essentially, I mean, all of this is confidential, but they won't have a commitment posted to their record, if you will, because it's a hold. We're just getting them past the severity of whatever the circumstance is. We still don't have any questions, right? Okay. I've been known to talk forever, so I can keep going. All right, physician's examination. This is really kind of the key. Why is it key? Because of a number of things that come about as a result of physician's examination. I'm going to run over my PowerPoint probably. First of all, they're detained under 229.11. They must be seen within 24 hours. Physician's examination doesn't only occur with a pickup, with an inpatient pickup. It can also be done on an outpatient basis. I try and encourage people to do it on an outpatient basis, realizing, of course, number one, the only time you can hold somebody inpatient for a commitment is if they're likely to physically injure themselves or others. Okay? So if they are incapable of providing for needs, or they lack, or they're likely to inflict serious emotional injury, those particular elements, that's not grounds for holding them during the interim. That's not subject to the quote-unquote 5-day hold that occurs. All right? Now I'm going to confuse you. When I say 5-day hold, that means when the person's picked up, we hold them for a period of up to 5 days before the hearing. Okay? So everybody understands that. We're not talking holds now, we're talking about an actual commitment. So if the person's detained under 229.11, they have to be seen within 24 hours. What does that mean? Well, Dr. Jones walks in up to the respondent and says, "Hi, I'm Dr. Jones. I'm going to be handling your treatment." The reason why that's true is because, generally speaking, and I haven't seen a situation where it has not been that way before, and that is mental health evaluations are done as a team effort. So you have a doctor, you have a social worker, you have nursing staff, you have pharmacologists, you have a whole team of people that are doing the constant evaluation. So it's not important that the doctor see him 24 hours a day, 7 days a week. The doctor's going to take all this information that they're receiving from all these people that do see him 24 hours a day, 7 days a week, and they're going to consolidate it into their report, and that's what's going to come to you, is the report. So the report is filed with the court within 5 days, and it's good for a 48-hour period. The reason why I know that is because I argued Melody L before the Supreme Court, and that's what the Supreme Court told me after I got done arguing it. So it's filed with the court within 5 days, and it has to be done within 5 days. And it's good for 48 hours. Now, it can be a longer period of time than 5 days, but only if agreed to by both parties. There are copies that go to the attorneys, so the attorneys will have copies of these reports. They are not to share them. Now, the respondent, certainly, you can share it with the respondent, because the respondent, it's his report. Obviously, it has to do with him. So respondent's counsel can share it, but the applicant's counsel cannot share it with the applicants. The applicants are not entitled to a copy of this report. Remember one thing, if we get into, and if I have time, we'll talk about 229, 24, 23, 24, and 25, which has to do with the rights of the respondent, and those are huge. And one of the things that go along with that is that everything that's contained within the report is confidential, can't be shared in a public venue. Those of us who are old enough to remember Senator Eagleton and what it did to his career because he had a mental health commitment will understand why we don't want that going out into the public. So it's shared with the attorneys. If it does not support a finding of serious mental impairment, the court on its own motion or by motion of counsel can dismiss. So you get the report back, and the report says not mentally ill. I think that's fatal. The only person that can make a determination with respect to mental illness is the doctor. So the doctor says the person's not mentally ill, the case is over, dismissal, go home, all right? With respect to other elements, I sometimes have difficulty with that. Now, I know what the code says, but what I'm going to say to you is, if the report says that they have judgmental capacity, well, why do they have judgmental capacity? Because while they've been in the hospital in a structured environment, they're doing everything the doctor tells them. Well, think about it in another vernacular. If you're in prison, generally people who are even murderers do what the jail or the prison tells them to do. Why? Because they are prisoners. You've got a person who's hospitalized in a substance abuse or mental health setting. They're going to cooperate for the most part. There are some who don't, but a lot of them will cooperate. So I'm always questioning. We have a person who, I'll give you an old example. We had a person who drove through his in-laws' house in his Jeep, got out in the living room, and the doctor said, well, he has judgmental capacity. Really? Okay, so anyway, he'd been talked to earlier and said, look, I think you need to get some help, we need to go. And he said, no, there's nothing wrong with me. And then he took his Jeep and drove through the living room. So anyway, that's why I sometimes question whether or not the doctor really can make that determination. And then the determination with respect to dangerousness, same thing. The doctor said he's not dangerous. Well, I don't know. Anyway. All right, the hearing is pursuant to 229.12, the Iowa Code. All right, this next bullet point, this is key. If you don't understand it, you need to. The respondent's welfare is paramount. That is the key. The purpose behind this has nothing to do with incarceration. It has nothing to do with penalizing the person. It has to do with one purpose and one purpose only, and that's treatment for an individual who, as a result of their mental illness or substance abuse, are unwilling or incapable of doing it on their own. So their welfare is paramount. That implies two things. Number one is least restrictive environment. So we put them in the environment that is least restrictive for them to get the appropriate care that they need. I'm not going to tell you that I've never opposed a doctor when the doctor says outpatient, because sometimes it's really bad. We had a guy come in one time who was sitting in a wheelchair drooling on himself, and the doctor said outpatient. Well, I'm sorry, this person can't handle, he can't care for himself, period. And so we look into whether or not that's going to be in the best interest of the respondent. And that has to be the thing that's always in your mind. Is it in their best interest? If they're being passive and they're not creating any problems, and the only reason why they're hospitalized is because they couldn't care for their needs and they're in a nursing home, I have a real difficult time saying we need to keep them inpatient. They're already in a structured environment where they're getting the treatment that they need. So the respondent's welfare is paramount. That's the key. I think you've got to realize that. If you don't realize that, and you're looking for, if you will, notches on your gun, that's just not going to be beneficial to you. Okay, presentation of the case. The applicant's evidence is presented by the county attorney. That's my role. I know I sometimes go beyond that role because I take an active interest in a lot of this, but that's the role of the county attorney, is to assist the applicants in presenting evidence. So one of the things that needs to happen if you are the county attorney and you're listening in is you need to call those applicants. If you haven't talked to them and you don't know what's going on with them, I don't know how you can assist them. But you're there to assist them in presentation of the evidence. The applicants and examining physicians must be present, okay, except 12.19, Rule 12.19. It says that and now it's changed slightly too, may be waived, all right? But who does it have to be waived by? It has to be waived by applicant's attorney, respondent's attorney, and the court. Now, if the court makes a determination that they're going to be waived, okay. they're going to be waived. So if you come in and your applicant doesn't show up and you say, look, we don't need the applicant, we've got all the information we need from the doctor, the court may waive it. I've only had that happen once, and if you can do the math, figure 360 a year times 24 years, almost 25 years. That's one time that I've done it, and so truthfully the applicant must be present. Why? Because they're the ones with the information. They're the factual information upon which the doctor is basing their opinion. So you have to have that factual information from the applicant so that the doctor's opinion carries forth. You can sometimes do that where respondent walked in, started pounding on staff, beat up all the staff members that he was responsible for bringing them in, and the doctor's sitting there watching, he's going, okay, well, this guy's dangerous, all right. I don't think you need anybody else to help you. But generally speaking, that's not the situation. So what you're going to have is you're going to have the applicant who can testify to the information that the doctor's relying upon in rendering his opinion, okay? Findings. It's the proof is by clear and convincing evidence. Once again, you need to realize it's got to be clear and it has to convince the fact finder. It's similar to beyond a reasonable doubt, but not as strenuous. Okay? So it has to be clear and convince the fact finder. And if they're seriously mentally impaired, pursuant to the code. And one of the things I want to talk about just real briefly, realize that the new definition for Chapter 125 is that they are suffering from a substance-related disorder of sufficient duration to meet the diagnostic criteria specified within the DSM-5. Folks, I mean, as I understand it, that is a mental illness, okay? So even substance abuse now is a mental illness if you look at it. So if they're seriously mentally impaired, the respondent is placed in a facility, and note this, under 229.13, either for mental illness or substance abuse. Now, I got into a lot of trouble. I can tell you that. When Mount Pleasant was open, we would send people under a 229 order of commitment, and Colin Alford would call me, and anyway, he would call me nice names. But anyway, he would call me up and he'd say, what is this person doing? And I said, look, 229.13 allows for that. And he'd say, yeah, but we don't have that particular pot of money. So I know that there's a problem there with respect to the pot of money for Chapter 125 and the pot of money for 229. And there's some reason they're separate pots and all that kind of stuff. But realize what 229.13 says. So if they need under 229, they're committed under 229, and they need substance abuse treatment, you can get that. Now, the other thing I will say is if you look at Chapter 125, there's not a similar provision in 125. So if you get a person in under 125 and you commit them, and the reason why they're being committed is mental health, they can't be sent to a mental health facility. The only place they can be sent to is a substance abuse facility, because that's all that's permitted under 125.
We do have a question.
Okay.
Do applicants stay for the entire hearing or only give testimony?
Okay. The question is, do applicants stay for the entire hearing or only for testimony? I've had that experience. I had a social worker come in one time and it got to be 4:30 and she said, I'm going home. They only have to stay until such time as their evidence is presented. So they don't have to stay for the whole time, but we have to have them there long enough to present their evidence, because once again, why are we doing this? We have to have the evidence of the applicant in order to use that applicant's evidence to bolster the doctor's report from a factual basis, okay? All right. I look in here at Cindy. Better than Mark? Appeal. Pursuant to 229.21, you can take what's called a trial de novo. They call it an appeal in the code. What it amounts to is a new trial. It has to be within 10 days of the magistrate's order. De novo appeal is a new trial to the district court, which means that you go in, you present the same evidence. Now, I know that there are some courts that rely upon the record below. I look at the term de novo, which means brand new, of the new. So I think you have to have new evidence. Not new evidence per se, but you have to represent your evidence. You can't rely upon the record below. It's before the district court at the earliest practicable time. I will tell you, I don't know if everybody who's listening has EDMS, but as a result of EDMS, our turnaround time is really, really fast. It used to be 10 days, 15 days before we get it. Well, now it just as a matter of a week. So if they take the appeal by Thursday, they're going to be in a hearing the next Thursday. It goes pretty fast. Now, it's no longer in some counties because the referees no longer exist. So the original 229-21, which took the appeal, said that you can appeal from a referee's decision. Well, now they allow you to appeal from a magistrate's decision. But in some cases, we don't have any referees, okay? And we don't have any magistrates. So what it amounts to is a hearing in front of a district court initially. Realize, of course, one thing. The district court has original jurisdiction. The jurisdiction of these matters is originally in front of the district court. So what it amounts to is kind of a do-over, if you will, in front of the district court who has original jurisdiction. So some counties will not have one of these, and the reason is because the person who's originally hearing the case is a district court judge. And then you have Rule 6.103, Rules of Appellate Procedure. You can take an appeal from all final orders and judgments of a district court. So you can take, once the case has been heard, you can take it in front of the in front of the Supreme Court. I'm calling myself a printer. That came out in LDL. So what we argued, there were a number of things we argued in LDL. The first one that we argued in LDL was that we're going to object to the fact that we're not allowed as the applicant an opportunity to appeal this case. And the appeal was based upon equal protection. The Supreme Court bypassed that and they said, well, you know, while we agree with you that that the procedure was improper, it's already done, so we're not going to pick her back up and bring her back in. But we will agree that you can take an appeal to the Supreme Court. You just can't take an appeal to the district court. Any questions on that? Okay. All right, there are some problems on appeal. The big one, okay? 229.17. Now, this is what it says in the code. And if you read through it and you have insomnia, you can probably be all right. But anyway, what this says is if the respondent was previously taken into custody under 229.11, and generally speaking, that's what it is. They're taken into custody under 229.11. I don't know very many that are done on an outpatient basis. I encourage that to happen, but I know it doesn't across the state. But if they're taken in and they've been hospitalized for psychiatric evaluation and appropriate treatment under 229.13, which is the initial commitment order, before the respondent's informed of the intent to appeal its findings. So if they're already hospitalized before the appeal, they have to remain in custody as previously ordered by the court, inpatient. Now, I don't know about any of you, and I don't know how many of you have taken appeals, and I don't know how long the appeal time is currently, because a couple of years ago, the Supreme Court said that the county attorney's office doesn't do appeals, and the only people that do appeals are the attorney general's office, and the trial is done by the county attorney's office. But the last time I did an appeal, the waiting period was 6 months. And I know, because I've heard, that there is some sort of administrative order out from the Supreme Court that says they can be released early under the report. I don't know how that's done. I haven't had a chance to look at it. But I can tell you that's a problem. Because number one, the hospitals don't want to hold them for 6 months. Number two, obviously the respondent doesn't want to be there for 6 months. They probably wouldn't have taken the appeal if they wanted to be there to start with. So just kind of an aside, one of the areas of, I think, the conflict between the rights of the respondent and the process. Treatment. Treatment is done pursuant to 229, 13, 14, and 15. Initially pursuant to 229, 13, and we've already talked about that. Hospitalized for purposes of substance abuse or mental health. 229, 14 is a follow-up of 229, 15. 229, 13 says, now I'm going to run over my PowerPoint again. Here we go. Has to be an evaluation within 15 days, okay? So 15 days from the initial commitment, there's an evaluation. That doesn't mean it has to be 15 days. It says within 15 days. So anytime from day 1 to day 15. I've done a number of cases where the doctor said outpatient. I've managed to commit them inpatient. The doctor gets out their pen, and with a stroke of a pen, they do a report and they're out the door. So within a matter of hours after we've committed them inpatient, they're out the door. But realize one thing. When you're dealing with these cases, we as attorneys are responsible for the determination, in the court is responsible for the determination of whether or not the person is seriously mentally impaired or suffering from a substance-related disorder. That's our responsibility. After that, treatment decisions are made by the doctor. Is it inpatient? Is it outpatient? What sort of treatment do they need? Those are treatment decisions that are made by the doctor. And I think that's appropriate because, truthfully, we're not doctors. And I know that I've been practicing for a long time, and I know a lot of the doctors would like to be lawyers. However, we as lawyers would do pretty poorly if we walked in and tried to remove an appendix. I've always threatened to do that, but I know that that's not something that we can do. And so treatment decisions really have to be in the hands of the doctors because they're the ones responsible for the patient. That 15-day evaluation determines one of 4 things. The person needs to remain inpatient. The person can be placed on outpatient. The person can be transferred, or the case needs to be dismissed. There's nothing wrong, nothing more to do, okay? Inpatient obviously is pretty obvious. Outpatient means that they are no longer housed in a facility. Doesn't mean they don't go for treatment schedules. It just means they're no longer housed in a facility. Transfer. People always get worried about transfer. Well, they're going to send this person all over. Generally speaking, the only purpose, the only time you're going to see a transfer is where the person needs to go to a specific type of treatment. There are a couple of those, or it used to be a couple of those. I know Clorinda's closed now. I won't talk about that. I do occasionally. But Clorinda used to have a geriatrics unit. So you had somebody who had a geriatrics case, they would send them to Clorinda. Why? Because it has a geriatrics unit and they're experts at handling that sort of stuff. The U of I has one for eating disorders. We send people to the U of I for eating disorders. That's another one of those. But it's specifically for purposes of getting the best potential treatment that we can. And then obviously dismissal. Okay, escape from custody. People always worry, what about if this person runs, okay? And they've been known to do that. They don't want to be there, and so they run. Well, if that happens, if the respondent leaves the hospital without the permission of the chief medical officer, whoever that person happens to be, the chief medical officer contacts the sheriff, who shall take the person back to the hospital. So if the doctor's saying you need to be here, and the person says I'm out of here and leaves, all they have to do is contact the sheriff, and the sheriff can pick them up. They don't need a court order in which to do that. The code already provides for that. If the sheriff's office wants a court order, I'm sure the judge would be more than willing to help them out with that. But essentially, that's what happens. Periodic reports. Those are under 229, 14, and 15. Remember, the 13 is the initial commit for 15-day eval. After that, 14 and 15 have to do with if they're inpatient, 30 days after the initial 15-day report, they receive a report. Once again, within 30 days after the initial report. Thereafter, within 60 days. So every 60 days thereafter, a report has to issue until such time as they're out. If they're placed on an outpatient basis, after the initial report, 60 days after the initial outpatient order, there's a report due, and every 90 days thereafter. So we have periodic reports, and the reason for that is because Kelly Agee, who's our patient advocate, and if you don't know who the patient advocate is in your county, find out. They're wonderful. I can't tell you enough good stuff about them. Kelly talked to me yesterday, and she said, I understand you talked about me. Well, yes, I talked about you. And I don't want her to get embarrassed, and hopefully she'll plug her ears, but she's a great resource. If you don't know who your patient advocate is, you're missing out on one of the most wonderful resources you can have. They're the person that goes out, meets with the respondent, meets with them on a periodic basis, finds out what's going on, reviews physicians' reports, reviews all the medical records, and decides, should this person remain in here? And then they have a tendency to twist the doctor's arm and say, get them out of here, okay? Remember, respondent's welfare is paramount. So this is one of the people that gets the job done, and like I said, I can't say enough good things about the patient advocates. Okay, in addition to periodic reports, there's a case out there called Salcedo versus Woodbury County. Salcedo was a case where the individual was in Woodbury County. Woodbury County determined that they weren't going to treat for this particular condition. And Salcedo said, I have a right to be treated. And so they have a right to what is called a placement order, okay? Or a placement transfer from one particular placement. If you're in, let's say, the average hospital, we already talked about transfer. You want to go to the geriatrics unit. You can ask that I be allowed to go to the geriatrics unit because I'll get the best treatment there. So there's a notice to the respondent and respondent's attorney of the initial order. Then they have a right to request a hearing in writing within 7 days. Now, the order I'm talking about is any of these orders. So if you start out with the initial order, and I've always been questioning that, under 229.13, the initial order, obviously placement was one of the things that should have been considered in the original commitment hearing. It may not have been. But if they come in and they say, we would like to have a placement hearing after the initial commitment, and we want to go to XYZ, understand something. When we're talking about placement hearings, we are not talking about a writ of habeas corpus. The issue is not whether or not the individual is seriously mentally impaired. That's not the issue. The issue is whether or not they should get treatment at hospital A or hospital B or some other hospital. And so they have a right to request a placement hearing within 7 days. The hearing is to be held no sooner than 4 days nor later than 7 days unless agreed to by the parties. Okay? All right, discharge and termination proceedings. This is one that I always find of interest. In light of 229.14a, we have 229.16, which says the doctor may tentatively discharge, giving an immediate report to the court. Now, sometimes the doctor's discharged without the report. I always encourage, in light of what we've got, you've got the fax machine, you've got email, you've got all that sort of stuff. EDMS has reporting capabilities, you've got all those sorts of things. So if the judge gets the report in the morning, by the afternoon, they're going to be gone. So I always encourage doctors to let the court make the order, don't tentatively discharge. And the reason for that is because of 229.14a. Do they have a right to a placement hearing? If they have that right, you discharge them. Now where are you at as the doctor? So once again, there's no conditional release under 229.13 through 15, and they have a right to a placement hearing. What happens? So I encourage my doctors always to send the report. We're going to discharge them. Send the report. Get the order back. Discharge them. Now you have the protection of the court's order. And the court has judicial immunity, obviously. The doctor doesn't have that. So that's just a suggestion. Respondents' rights. In an effort to secure respondents' rights, there have been several provisions created in Chapter 229. The first one is the patient advocate, 229.19, okay? I've already talked to you about her. Rights and privileges of hospitalized persons under 229.23. Confidentiality under 24 and 25, and the writ of habeas corpus and out-to-in proceedings under 14 and 23, okay? Patient advocate. I've already said this, and I'll continue to say this. They do yeoman's duty with respect to these cases. Their provisions for the patient advocate's duties are set forth in 229.19. They include, and notice it says, but are not limited to, reviewing each report. If the advocate is not an attorney, and a lot of them are not, we have nurses and we have a lot of other different types of people to advise the court at any time they require an attorney's assistance. So if they need an attorney to help them, they have a right to ask for that. To be readily accessible for communications from the patient, from the respondent, and to originate. That means they have to actually go see the patient within 5 days of the commitment. Why? Because everything kicks in about 10 days. So they need to be there to be able to kind of advise the respondent. Our patient advocate does on a regular basis. Sometimes we don't see eye to eye on cases that she wants to appeal, but that's okay. To visit the patient within 15 days of the patient's commitment, okay? So they have to take communications and have to meet with them 5 days after the commitment, but they have to visit with them within 15 days. So they can get on the phone and call. I know that Kelly doesn't do that. Kelly actually goes to the hospital. I'm always seeing Kelly out at Broadlands, and I say, what are you doing here? And she says, well, you put people in, I go visit them. So to visit the patient within 15 days, to communicate with medical personnel about the treatment, okay, and review their medical records. Now, in Polk County, we have kind of a blanket order, not a blanket order, but we have an order that we issue regularly once the person's committed so that the patient advocate has the ability under court order to see this. But under 229.19, they have that right anyway. But we try and clear it up for everybody. We're certainly welcome to work with the patient advocate any way we can. To file with court or quarterly reports. I don't know about every other county, but in Polk County, those are voluminous, okay? I don't know how the court gets through all of that, but she does an excellent job of making sure that those are all reported, okay? All right, rights of hospitalized persons under 23. As you notice, the type keeps getting smaller and smaller because it's more and more, okay? So prompt evaluation, necessary psychiatric services, they're entitled to those. The right to refuse treatment by shock therapy or chemotherapy initially, and even after they're committed, they have a right to refuse shock treatment. Now, they don't call it shock treatment anymore. Now it's called ECT. Realize this was passed in 75. I'll be honest with you. I've always considered ECT and shock treatment to be barbaric. But if you talk to several of these doctors who administer those sorts of treatments, they'll tell you that they are wonderful. Now, I had an instance a number of years ago where we had a young woman who believed God had abandoned her. And the interesting part about that was the hearing was at Christmas. So she believed God had abandoned her, and she couldn't eat any proper food. So she couldn't eat anything that tasted good. So her diet consisted of raw potatoes and radishes. She got chemotherapy because it can be consented to by the next of kin. So she got chemotherapy, ECT, and it was wonderful. And she came back, and she was doing really, really well. And then she quit taking the medication because obviously it works in coordination with the medication. She quit taking the medication, and she came back again, this time at Easter. So anyway, but they have a right to refuse shock therapy or ECT. That can be consented to by family or next of kin. The court will not get involved in that. The court has a prohibition against issuing an order for ECT. Chemotherapy, obviously, once the person's hospitalized, they can give them chemotherapy against their will. In addition to that, constitutional right of enjoyment of legal, medical, religious, social, political, personal, and working rights and privileges. Okay. Where am I at time-wise?
10:05, so we're a few minutes over.
I'm over? Okay. All right. Well, I'll run through this real quickly. Confidentiality records, once again, they keep getting smaller. There's only 2 ways that you can receive information under 229. So we never really worry about HIPAA that much because the only way you can get it is either by a court's order, which is permitted under HIPAA, or by release, which is also permitted under HIPAA. There are a number of other things too. We don't have any of that additional stuff. Those are the only two ways you can get information. Okay. Like I said, we didn't have enough. We didn't have small enough type, so we have to keep going on the next page. All right. Habeas corpus. Under 229.37, there's a right to habeas corpus. Best way to kind of get an overview of the writ of habeas corpus, I'd look at BAA versus Chief Medical Officer. It's set forth in the outline. Juveniles, 229.6A, 232.49, and 232.98. Juveniles, generally, if they come under 229.6A, it's the same process, it's the same procedure. The difference is where the jurisdiction is. The jurisdiction is not in a regular court, it's in the juvenile court. And then I'm obviously run out of time, but here's a number of opportunities, things you may want to think about, some of which I've already covered. Any questions?
One more question, and I'm going to pop it up here because it's a fairly long question.
Can we do that?
It's the hospital doesn't have resources. Okay, I'll choose Committal.
Okay. The question has to do with the local hospital receives a patient who has been served a committal papers and the hearing is set for 4 days from now. The hospital does not have inpatient mental health services only. They only have ED crisis options. This is great. Sheriff leaves the patient at the hospital. There is no inpatient facility in the county hospital. Makes all necessary to find placement. Let me explain something to you. First of all, understand that it doesn't require a psychiatrist. You do not have to have a psychiatrist for the opinion, for the initial opinion. And the other thing is, based upon the amount of bed space, and frankly, it's terrible. But based upon the bed space, you could potentially have a person at your hospital in a regular medical bed being evaluated by a physician. It doesn't need to be a psychiatrist. So the physician can do the evaluation, and then the physician can present that at the hearing. The physician is able to testify at the hearing. They don't have to be a psychiatrist. I love the fact that I live in Des Moines and I have that, but I've been to the Hill a number of times trying to get additional parties that have that ability, physician's assistants and advanced registered nurse practitioners, and you'll see that kind of scattered through the statute that we now allow them to do other things, but they can't do the initial hearing. But physician is all it takes. So if you're licensed, and I can't remember, one's 49 and one's 50, but if you're licensed to practice medicine either as a DO or as an MD, you can do a report. And so that's really all that's necessary. I hope that answers the question. I don't know. It goes on. Let's see. I'm sorry. It says who's been served committal papers and the hearing is set for 4 days from now. Hospital does not have inpatient mental health services, only ED. Sheriff leaves the patient. Let's see. There's no inpatient facility. Makes the call necessary to find placement. A transfer patient decides they wish to leave. What should the hospital do? They can't leave. They can't let them leave. They've got an order. The order says they stay there. The other thing I would encourage you to do, one of the things in the opportunities that I talk about, and that's the county plan. So look at your county plan and find out what the county plan says as to where the person is to go pending the hearing. The county plan is supposed to set forth where your emergency mental health services are provided. Okay?
Let me double check to make sure there's no more questions. Oh, one more time, the name of the Polk County patient advocate.
Kelly Yagi. And 250-6150. That's her phone number. So if you've got a question, call her. And she's going to kill me now, so.